This section will relate to employment ethics and laws and teacher rights and responsibilities. There are several laws at the federal level that impact in both of these areas. Americans with Disabilities Act, the Age Discrimination and Employment Act, the Consolidated Omnibus Reconciliation Act, the Employee Retirement Income Security Act, Executive Order 11246, that's the presidential order, the Fair Labor Standards Act, the Family and Medical Leave Act, FMLA, and the Occupational Safety and Health Act. Also, Sections 503 and 504 of the Rehabilitation Act of 1973, which has to do with disability discrimination, the Civil Rights Act of 1866, which was not updated until 1981, having to do with race discrimination, the Civil Rights Act of 1871, that was updated in 1983, Title VII of the Civil Rights Act of 1964, and the Worker Adjustment and Retaining Notification Act. All of these acts have to do with employment that you will, in your careers, be faced with. Let's talk just a little bit about the Civil Rights Act of 1866, looking at the changes that have come from the wording. So, for example, in the middle of the Act, in the middle of the section, Section A, it talks about to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens. As it goes on, the Supreme Court determined that the word race will not be part of this section when it was updated in 1981, and that it forbid all racial discrimination making of private and public contracts, and this is to include all ethnic groups. And you'll see the sources www.elinfonet.com. In 1989, the Supreme Court ruled that this section 1981 would be limited to the making and enforcing of contracts not after the contractual relationship had been established. Title VII of the Civil Rights Act of 1964, which was a monumental act signed by President Lyndon Johnson shortly after the 1963 assassination of John Kennedy, made it unlawful for an employer to hire or discharge any individual or otherwise to discriminate against any individual with respect to his or her compensation, terms, conditions, or privileges of employment because of an individual's race, color, religion, sex, or national origin. This section covers all hiring, firing, promotions, and workplace conduct. Many times, what we see is when an individual is discharged for not very good cause or for a controversial reason, they will file a complaint with the Office of Civil Rights and who will request a great deal of information from you. You'll notice the 6 remedies and damages that can be awarded based on violations of Title VII. Sexual harassment is a form of sex discrimination which also violates Title VII of the Civil Rights Act. This is what I would consider the water cooler act. It involves unwelcome sexual advances, requests for sexual favors, etc., unreasonable interference with the individual's work performance, or creating an intimidating, hostile, or offensive work environment. Title VII goes on to discuss that when the Act was amended in 1991, it provided for the recovery of damages for intentional violations of Title VII. The next act to discuss is the Family and Medical Leave Act. FMLA allows for employees to request a period of up to 12 work weeks of unpaid leave during any 12-month period for one or more of the reasons noted on the slide. Americans with Disability Act is a federal civil rights law that was designed to prevent discrimination and enable individuals with disabilities to participate fully. It also means that when a person with a handicap or a challenge presents themselves for employment, if they are capable of handling the responsibilities of the position, they should not be denied employment because of having a wheelchair or crutches or other aids to assist them to do their job. As long as they can contribute to the fundamental responsibilities of that job. You have to make sure that people with disabilities have an equal opportunity to provide services for jobs and to work in jobs for which they're qualified, that they have an equal opportunity for promotion, they have equal access to benefits, and they're not harassed because of their disabilities. These are important provisions. Confidentiality, reasonable accommodation, undue hardship, discharge or non-employment of a job candidate due to safety issues, and drug and alcohol use on the job is not a protected right of the Americans for Disabilities Act. Section 503 of the Rehabilitation Act allows for accommodations to be provided for employees with potential disabilities. Section 501 provides a focus for the federal and other employment of individuals with disabilities, and it also protects the special needs of such individuals to make sure that they are not discriminated with in the employment process or on the job. The Age Discrimination and Employment Act indicates that it's not a violation where age is an occupational qualification. The case shown is Western Airlines, which no longer exists, versus Cresswell, where the airline forced a pilot to retire at a certain age. We generally do not force our employees to retire unless their job performance becomes such that it interferes with the ability of students to learn. The Occupational Safety and Health Act, we have to make sure that our buildings are free of hazards that are likely to cause serious injury. Every state requires fire marshal inspections and other inspections of schools to make sure that this doesn't happen. In Indiana, there's an Employment Relations Act. There is a United States Employment Relations Act. It indicates that in this case there was an employee who was sending out communication from the union to union members, and that the district indicated that they were going to remove the person. They filed letters of reprimand, and the president of the union filed an unfair labor practices complaint, and it was found that the district in violation of the State Collective Bargaining Act at that time. The Indiana Employment Relations Act has changed since then. However, employers cannot interfere with union membership communication. There is a note of several other topics that can be looked at in this area of teacher responsibility, including liability for student injuries. A teacher is liable if the teacher leaves a student unsupervised. Teachers often will stick students in the hallway. This is not a good idea. If the student becomes injured, gets into a fight, suffers a seizure, and is injured in regards, the teacher could be found liable. However, if a student engages in activity where the teacher is present and the teacher attempted to intervene, they are not responsible if they've taken appropriate precautions particularly off-site by having chaperones, etc. In the area of the First Amendment, free speech and free expression, the Pickering versus Board of Education case, 1968, allows for a teacher's right to free speech, such as criticizing school authorities. Sometimes, as administrators, we get very angry with staff who has criticized an administrator for one thing or another that is not a violation of contract law. They are entitled to free speech as long as it doesn't materially or substantively interfere with the operation of the school. Scoville versus Board of Education. Freedom in speech does not include the use of fighting words or the abuse of superiors with profane and vulgar speech. That you can take disciplinary action for. Hurt feelings you cannot take disciplinary action for. We talked at the beginning of Module 1 about the Keefe versus Giannakis case, that a teacher may not be dismissed for selecting reading assignments that may have offensive words in it. In terms of teachers' private lives, Morrison versus the State Board of Education in 1969, a teacher's sexual orientation is not grounds for revocation of licensure as long as it doesn't affect the performance of professional tasks. Very important. Misrepresentation of a former employee. This employee, Randy W., sued the Monroe Joint Unified School District in California, and the court ruled that an employer can be held liable for making misrepresentations in a letter of recommendation. And it gives the history, and that he had molested a child in each of his districts, and each district gave him a positive letter of recommendation, but that the writer of the recommendation cannot misrepresent an employee's qualifications or character because of the risk of further harm. Most administrators get very concerned that if they write a poor recommendation, the employee will come back and sue them. If you keep your silence, it may or may not have a legal action attached to it. This is important, particularly in sexual abuse cases. There are a number of cases where school boards and superintendents are aware of an abuse by an employee, and they fail to notify a subsequent district that the employee works for. It becomes very critical that although a teacher has every right to protect themselves, they have no right to abuse children in any fashion, and the school district becomes party to that molestation or abuse by not reporting it. This will conclude this section on teacher rights and responsibilities and employment.